2020 educational series. This webinar is being offered as part of our strategic planning efforts to move towards web-based learning experiences for the next 3 years to reach more patients, caregivers, and family members who seek to obtain accurate information about scleroderma. There are individuals from all over the world that will access this webinar, emphasizing that we can be connected and sit in front of our computers obtaining accurate educational information while staying in our homes and offices. This program is being made possible in part by the unrestricted educational grants of Actelion and Boehringer Ingelheim. We thank them for their generous support to the scleroderma community. This webinar will focus on taking the mystery out of disability. The Michigan chapter and the Tri-State chapter will be presenting educational webinars throughout 2020, and you can locate information about them both of our websites and the National Scleroderma Foundation website. If you would like more information about these, you can find the information in the National Weekly e-blasts or on the Michigan chapter's website, which is all lowercase scleroderma.org/Michigan, and Michigan is spelled out, or the Tri-State website, which is also lowercase scleroderma.tristate.org. We have Michigan disability attorney Gary Bimberg with us as a presenter today. Social Security has its own rules, courts, and judges, and Gary Bimberg, managing partner of Levine and Benjamin in Michigan, exclusively practices Social Security disability law. Over the years, he has become an expert in the field and is a frequent speaker and presenter with a signature lecture titled An Advocate's Overview of the Social Security Disability Claims Procedure. Gary even wrote a book called How to Handle a Social Security Disability Case in Michigan. He serves on the board of the directors for the Disability Network Wayne County and has worked with the Scleroderma Foundation Michigan chapter for several years and has helped many scleroderma patients in the state of Michigan. The Scleroderma Foundation welcomes Mr. Bimberg to present this webinar today and looks forward to the scleroderma community having accurate information about disability claims and procedures. Thank you for being with us today, Gary, and welcome.
I appreciate the introduction. I'm happy to be here. Thank you.
Thank you very much, Gary. Like I said, just so I give everyone just a little additional information besides on Gary, but the way this webinar is going to be a little bit different. Normally, Gary gives this webinar in front of a larger crowd, but Michael has gone through the process along with my late wife. So Michael and myself will be acting as a studio audience today, asking the questions, hopefully answering some of the questions that I'm sure that will come up after you hear Gary speak. So with that little blurb, Gary, I'm going to let you start the presentation.
All right, thank you. Well, generally I want to talk about three particular topics here about Social Security disability. Now, even though I'm speaking to you and I'm an attorney from Michigan, Social Security is a federal program. So what I'm telling you today is not unique to Michigan. These are the rules and regulations that are used throughout the entire country, all 50 states. And as an attorney, even though I'm in Michigan, I do have clients all over the country, and I travel all over the country helping people with Social Security disability cases. So even though you may not be in the tri-state area or Michigan, what I'm telling you today is certainly be applicable. Now, I'd like to talk about three different topics here under Social Security disability. And again, you two jump in with any questions or help guide me as to where you think your audience might be more interested. One of the particular types of disability cases, that's the first thing I want to talk about. Not everybody who is disabled is entitled to disability benefits. You have to fit within one of the particular programs. I'm going to talk about those. The second topic I want to discuss is what does it mean to be disabled? What's the disability definition, and how is a finding of disabled made? What does it mean, and what's the criteria? And lastly, what's the actual process? You know, from application all the way into the United States federal court, what are the steps that you have to do? And we're going to talk about that. Lastly, I'm also going to touch upon some changes in the law. There are some changes that are coming down the pike and some proposed changes that people need to be aware of. So to begin, the different types of disability programs, the first and most common type of program is called Social Security Disability, or it's often referred to as Disability Insurance Benefits, DIB benefits. That is a type of program for people who have worked and paid into the FICA system. So that means you have paid your FICA taxes, that's your Social Security taxes on earnings, and you have earned enough work credits to then draw off of your earnings. Now, I'm sorry?
So let me ask you, is that, so basically we're saying is that for you to be qualified, you must have 40 work credits, correct?
Correct. You have to have 40 work credits. And the easiest way to look at that is there's four credits in a year, okay? So Social Security is going to look in the last 10 years of your life. There needs to be some combination of at least 5 years within the last 10 where you had some earnings and you were paying taxes on those earnings. One thing to remember, and that's becoming unfortunately more common in the gig economy, or people are independent contractors, work means work where you're paying taxes. Okay, you have to be paying FICA taxes for it to count. If you're being paid in cash, or if you're getting 1099 and you're not paying taxes, you're out of luck. So your credits are come from paying FICA taxes. So yes, some combination of 5 years of earnings within the last 10 will get you something called insured status and allow you to apply for Social Security disability.
Okay. Thank
you. Sure. So that's the most common type of program. And talk about insured status. One thing to keep in mind is that insured status, meaning your right to apply for Social Security disability, will eventually run out. All right. Think of it like a statute of limitations. All right. You may understand, or people would know, for instance, if you got in a car accident, there's only a certain window of time. Generally, it's 3 years we could bring a lawsuit. After that, you're out of luck. Social Security disability is kind of the same way. And then once you stop working and paying your Social Security FICA taxes, there's only a 5-year window to prove disability. So one of the things I really want to stress to people is once you become disabled, once you leave work and know you're not going back to work, you should file for benefits right away, because eventually your ability to collect will run out. You will lose that insured status, and even though you're disabled, you can't get benefits. So that's one thing to keep in mind for Social Security disability. With your Social Security disability, the monthly amount you receive is based upon the amount of FICA taxes you paid in over the years. So everyone's rate is different. I get the common question, well, how much am I going to get on Social Security disability? The answer is I don't know. Depends on the amount of taxes you paid. I've seen people with rates as low as a couple $100 a month and as high as $2,500 a month. I can tell you the average American rate is about $1,200 a month. So that's the average rate. So if you can take it from there. With the Social Security disability, you also receive Medicare health insurance, which is important. So not only do you get your cash benefit, but you receive your Medicare. Now, there is a waiting period of 24 months before the Medicare kicks in, but you'll eventually get that insurance. One last thing to know about Social Security disability is that it does not change when you hit retirement age. People often ask me, well, what happens when I turn 66? What happens to my disability? And the answer is nothing. In essence, when you go off on Social Security disability, you're getting your full Social Security rate early. So you are receiving what you normally would have received at your full retirement age, and they give it to you early and call disability. Once you hit retirement age, the amount stays the same. The name just changed from disability to retirement.
So
that's the most. Yeah.
So what you're saying is that, and I'll use some terms that as I get closer to 65, I'm learning more and more terms, so basically you're collecting your full FRA number then, your full retirement applied number. And
correct.
So
you're getting the full amount as if you would have continued to work.
Okay, so you don't get a discount. In other words, if people are concerned if they draw early, if they're not disabled, they have a reduction. So if you're 55 and you have enough credits, basically you would get the amount that you would receive at 66 or 67 then for those 12 years, and that would continue.
Exactly.
Okay.
Yes, and to take your comment a step further, let's say your person is 55 and for whatever reason they decide not to file for disability, they'll say, well, I'm just going to wait, until I turn 65 and get my Social Security retirement at that time. Well, the rate that they receive in the future is actually going to be reduced because there's going to be 10 years, for your example, of zeros on that person's earning record. So it's going to reduce the rate. So by going on disability at age 55, it freezes that full amount. It does not go down the rest of your life. So yeah, another reason to file right away and get that finding of disability, so it freezes your rate and it doesn't go down because you stop paying into the system.
Okay, thanks.
Now, sure. Now, there's a second type of disability program that people are aware of, and that's out there for people. It's called SSI, or Supplemental Security Income. A lot of people will get confused with the different acronyms and say, I want to file for SSI when they mean SSD or Social Security Disability. But SSI is another type of program for people who have not worked. So you don't have to have insured status. You don't have to work 5 out of 10 years. That's for people who haven't worked. However, SSI is like a welfare program. You have to show financial need. So SSI is for people who haven't worked and can show severe financial need. Generally, you have to have resources of less than $2,000 to qualify for SSI. You don't have to be homeless. You can have a home. You can have a car. You just can't have other resources to qualify for SSI.
What do you determine as a resource? What's a resource, sir? I don't understand. Are you talking about
sure.
account or
cash?
Okay, so
retirement funds, savings account.
Okay, so a total amount of liquidity or assets of $2,000, you have to have less than that.
Correct.
Okay. A
good rule of thumb, and this is how I screen my, when new clients call my office and I try to figure out what type of case they might be eligible for. If we're looking into SSI, I ask, are you receiving state assistance? Are you receiving food stamps? Are you receiving the state Medicaid? Generally, if you qualify for the state assistance, you're going to qualify for SSI. Roughly, they use the same eligibility rules. It's not exact, but roughly. So if you're eligible for state assistance, you're probably eligible for SSI. Now, SSI, however, the resources are attributable from person to person, meaning if you are married, all right, let's say use an example, we have a woman who didn't work. She stayed home to raise children, okay? She didn't have insured status. She didn't pay in. So we say, okay, let's look at SSI. Well, if she's married, her husband's income would disqualify her for SSI if it was more than $2,000, right? So you can't be married, or if you are married, your spouse has to have very limited resources. Also, a child can file for SSI, but they're going to look at the parents' resources. Again, they have to be less than $2,000. So it's type of welfare program. SSI receives a straight flat fee. In Michigan, that's about $780 a month. Other states have different supplements that make it a little less or a little bit more. That's about what you get. And you get straight Medicaid health insurance with the SSI. That's what comes with that. Okay. So those are the two most common programs, SSD, or Social Security Disability Off Your Work Credits. There's also something called SSI, which is like disability welfare. Very quickly, there's also disabled widows benefits. So you can collect benefits off of your deceased spouse's Social Security account, but the person who's claiming disability has to be between the ages of 50 and 59, and the disability had to have begun within 7 years of the spouse's date of death. So you can see it's a pretty narrow window, but it's something to consider. If you didn't work yourself, but your spouse did, and they had passed away within 7 years and you're above the age of 50, you can draw disability off of their account. Lastly, there's something called a disabled adult child claim. So if somebody is above the age of 22, but can prove that they're disabled or as a child, and they have a parent who's receiving Social Security, that child can collect as well. So those are the main types of disability programs that people are eligible for. Are there any questions or comments about those before I move on?
Yeah, I got one for you, sir. You said it's 65 now, because it's a retirement age. So I'm on disability. When I turn 65, automatically I go from disability status to retirement status, or how does that work, sir?
Yeah, the name changes, but the amount stays the same.
Yeah, right. But
to get real technical, your check is going to be coming from a different trust fund at that point from the government. Mm-hmm. It's going to stop coming from the disability trust fund. It's going to come from the retirement trust fund instead.
And that is automatic, sir?
Correct. There's nothing that you have to do.
Great. Okay, there you go. Thank you.
Sure. Okay. So the next topic I want to talk about is, what does it mean to be disabled, okay? So let me first of all explain what the disability standard is. The disability definition states that disability is the inability to engage in any substantial, gainful activity because of any physical or mental impairment which has lasted or can be expected to last at least 12 consecutive months. So that's a lot of verbiage there. Let me try to unpack that a little bit, okay? So disability, first of all, means the inability to engage in what's called substantial gainful activity. The acronym there is SGA. SGA means work. So you can't be working and file for disability. That makes sense, right? Disability is for people who are not able to work. However, substantial gainful activity has a threshold of $1,270 a month. So what that means is you can be working part-time. As long as your earnings are under $1,270 a month gross, you can still file for disability because you're not engaging in what's called SGA. So I get that question a lot. Can I still work while I'm filing for disability? Or somebody calls me and say, I'm still working, but I'd like to file. If they're working and making above that SGA threshold, you can't file. That's it. However, if they're off work or working below that, we can still file an application. Now, the argument has to be that the work you're doing below SGA is all that you're able to do because of your health, that you can't do more even if they offered it to you. But so you can work a little bit and still file. The next part of the definition is because of any physical or mental impairment. What that means is that Social Security is going to take a look at the combination of all your health problems. So you don't just say, I'm disabled because of scleroderma, or I'm disabled because of a bad back. They look at everything. It's the combination of your physical and your mental impairments, all of them bunched together. How does that affect you from working? And especially with something like scleroderma, where people have like a whole umbrella of symptoms, that's important. Everything is considered there, and including if you have some depression or anxiety issues. Lastly, the definition states that the impairment must last or expect to last for at least 12 consecutive months. So what that means is that when you are filing for disability, you are saying that you're going to be off work or expect to be off work for at least the next year. So it's important to understand that you do not have to wait a year to file. I mean, you could leave work on Monday and file for benefits on Tuesday. But when you are filing for benefits, you are saying that you anticipate remaining off work for at least the next year moving forward. So that's another common issue when people call me to say, I'd like to file for disability. Okay, when did you last work? Last month. Okay, well, do you think you're going to be off work now for at least the next year moving forward? Well, I don't know. So you only want to start that application once you're certain that you are going to be off work at least that long, if not longer. Because if we start a case and you go back to work before that 12 months is up, your case is dismissed. So that's the disability definition. Before I move on, is there any comments or questions about that?
Yeah, I have a question, Gary. That's a great example you gave. Let's say on January 1, I go in and I say I'm going to quit, and basically because I feel I'm disabled and I can't do my job anymore. So on January 2nd, I give you a call and I said, okay, I want to file, or I start the process and file for disability. Now, for some reason or whatever, I decided to go back to work in October. So it's under the 12 months. Now, if I went back to work, obviously, as you just stated, that case is now dismissed. And I try it for 3 months and I decide that I can't do this. I was wrong. I thought I was able to go back to work. Can I refile for the disability and then this time I'm going to be off forever? Can I redo it again, or am I disqualified for applying a second time?
No, you can refile, and you can refile as many times as you like. But I'm not sure you did this on purpose when you said 3 months, because I'm going to get a little bit more technical here. So in your example, the person left work January 1st and they go back to work in October, so that they're below the 12 months. Well, the day you go back to work, your case is not automatically dismissed. Social Security allows something called a trial work period. And the trial work period is generally defined as 3 months or less. So if you go back to work and within 3 months you find out that you can't do it anymore and you have to quit because of your disability, we can wipe that clean and your case could still continue, called an unsuccessful work attempt. So really, it's only after month 3, if you go back to work, that your case is in jeopardy. So in your particular example, we would not refile. The case would just still continue. And back to January, the original date. And we would argue that that 3-month work attempt was an unsuccessful work attempt and shouldn't count against you.
Okay, thank you.
Okay? So to make that disability determination, Social Security will go through a 5-step process called the sequential analysis. So they go through these 5 steps in order to come to that decision of disabled or not disabled. So once you file that application, the first step they ask at step 1 is the person engaging in substantial gainful activity, or SGA. So they're going to look right away, are you working? Okay? If you're off work or at least making less than $1,200 a month, you're not engaging in substantial gainful activity and the case proceeds. Yeah?
Yep.
Oh, did you have a question about that?
No, I'm good.
Oh, I'm sorry. Okay. All right. So step 1, are you engaging in substantial gainful activity? So if somebody calls me and says, I'd like to file for disability, but I'm still working full time, if they were to file a case, their case would have been denied at step 1. They're engaging in substantial gainful activity, case over. They're not even going to look to, are you disabled? They're not medically. So let's assume the person's not working. You move on to step 2. Step 2 asks, is the impairment severe? A severe impairment is defined as almost anything that would limit your ability to work. In our example here today, if you have a definition of scleroderma and you are getting treatment with a doctor, you certainly would have a severe impairment, so the case would move on past step 2 to step 3. Step 3 asks, does the impairment meet or equal what's called a listing? Now, a listing is a published set of severity benchmarks that says if you meet this very specific criteria, you're automatically disabled, no questions asked. Now, there is a listing for scleroderma, a listing 14.04 under the listing of impairments, 1404. Now, if you look at that listing, it refers to other listings, meaning scleroderma can affect your joints or your neurological standpoint. Basically, listings are very technical and very difficult to meet. Of 100 cases I win, maybe 1 or 2 are on a listing. So we have to look at it as part of the sequential analysis, but most cases aren't won by listing because the bar is set very high and is very technical. So if the listing is not met, the case moves on to step 4 of the 5-step analysis. Step 4 asks, can the person perform their past relevant work? Social Security will look at the last 15 years of a person's employment, and they will say, can they do any work that they've done in the last 15 years? So let's say we've got an individual scleroderma files for disability. Let's say the person was a nurse, okay? As a nurse, his or her duties were very physical. They're on their feet, lifting patients, walking around all shift. Because of the joint pain and fatigue, they can't do their past work anymore, okay? So you meet step 4, then you move on to the last step, step 5. Step 5 of the analysis asks, can the person perform any other work given their age, education, and past relevant work? Now, this is where the person's age becomes important. If you're below the age of 50, step 5 makes you prove that you can't do any work. So you can't do, an example, a nurse, but you can't do literally any other hypothetical job that exists. Even, let's say, a simple sit-down job, parking lot attendant, or telemarketer. There's no work that you can do. Okay? Yeah. You may ask, how can you prove that no one can do any work? Yeah.
Well, I want to make sure that I understand this because, like I said, I'm going to make a little reference back to my late wife's process. And does that mean when she retired and then filed, she was a general manager in a small company? And the reason why she ended up having the problem, obviously she had she had scleroderma, but she had a lot of the conditions that they have, the motion, the hand movements, the coldness. And the major one that she had was brain fog. And then that basically is that some of the times the scleroderma patients don't remember. And being a general manager is a little bit tough to run your business and be responsible for others and the finances of a company when that occurs. Now, and I'm sorry for rambling on a little bit, but let's just take the hypothetical is that if you made $5,000 a month, but they come along and say, okay, you can do another job, but that job now is basically, like, we'll just say as an attendant for a parking lot. But I'm only going to make $1,000 a month, or let's say $1,500, so above the threshold. Does that qualify, or do you have to have a job that you can do that you make the same amount of money?
No, Social Security doesn't consider the fact that your past work, you're raising a family and making a good wage, and the hypothetical job perhaps you can do is minimum wage. They don't care. If you can do it, you're denied. Literally, all hypothetical work you can't do, regardless of the pay.
Okay, thank you.
Sure. So it's a pretty tough standard. Now, how can we prove that somebody's completely disabled from all work? Well, we get the medical records, of course, and you cite a good example about the brain fog, for instance. So we would argue in a case like that the person can't concentrate, they can't focus, can't stay on task for 40 hours a week, even at a simple routine job, can't use their hands repetitively. Most work's going to require you to use your hands somewhat, of course, so they can't do that because of the pain, can't handle any temperature extremes, need naps. We send our clients, treating physicians, something called residual functional capacity evaluations, where we ask the doctors to fill out a short form checking some boxes, for instance, commenting how much weight the person can lift, how long they can stand, how far they can walk, can they manipulate their hands, or stay on their feet. And, if the doctor puts certain restrictions on there, and where somebody, let's say, can lift less than 10 pounds, can't be on their feet, less than 2 hours a day, the person is going to be restricted from doing any work based upon restrictions like that. Need to lay down to rest throughout the day. So that's how, we'd go about winning a case like that. Now, the rules shift become easier at age 50. So at age 50, you don't have to prove that you're disabled from all work, just that you can't do the past work that you used to do, and you're limited to what's called sedentary work. So in the nurse example, you can't do physical work anymore, but perhaps hypothetically you could do a simple sit-down, telemarketing job. Well, you'd win at age 50, all right, because it's what's called the grid rules, and it shifts and become easier. So that's important. Age is an important consideration for Social Security purposes. So that's at step 5 of the analysis. So that's where the vocational considerations come into play. Any more questions or comments about the disability definition or the 5-step process used?
I'm just going to throw this out there. You brought up about performing past relevant work, and what I used to do, I was a car salesman, and I also did financing for people with credit issues, but I was a top salesman and all that, but I worked 55, 60 hours a week. I was salary plus commission, and I begged my employer, because I was making millions. I just said, can I just go on the clock or something like that? And they refused. Once I released that I had scleroderma and had issues, I became a liability. I even went so far as contacting on my own former employees. When one was working in a newspaper office, just to see if I could do anything. They wouldn't even talk to me. So I tried all that. I included all that in my documentation. But what I'm going to throw this out there too is, I had all my documentation, but about a month before I was approved, I go through the U of M, and I had seen a thoracic surgeon at the U of M who was going to do a possible surgery on a fundoplication because of my Barrett's esophagus. He's old school, a gentleman that probably now is in his 70s, or maybe was at the time, but he's not a computer user, and everything was old school. And he wrote a note in my file and included, like I said, it came out about a month before I was approved. And the PDF file turned out to be 19 pages. And this gentleman had looked at my history from the day I became sick, and he had reviewed all my files back to probably pre-existing of scleroderma, but he went through step by step how scleroderma affected my body, what I have. The basic parameter of the summary of his thing was Mr. Bessert is disabled and he will never be able to functionally work again. And I called my person at Social Security office, Mount Pleasant, and I said, is this pertinent? She said, fax it right up. I did, and I swear that won my case, because they personally called me to tell me that I had basically made all 5 steps and I was approved. But
I'm glad to hear that.
Yeah, it was. Like I said, I'm an over documenter. So I think that would help me, but I didn't want to quit. I was 55. I needed the money. And, I was just trying to, come to grips that this disease was taking me over. Like I said, brain fog. I couldn't function day by day. But anyway, I wanted to throw that out.
No, that's a good a good tale to tell, and I appreciate you putting that out there because that's important. A doctor can go a long way in helping win a disability case. On the other hand, it's not necessary or essential. I'll have people tell me that my doctor doesn't believe in disability or doesn't want me to file for disability. Does that mean I don't have a case? And absolutely not. I just spent the last 10, 15 minutes describing what disability means. It's a legal term, as defined by Social Security. So to have a doctor say my patient is disabled doesn't really mean anything because disability is a very, complicated term, used and evaluated by Social Security. What is important is for the doctor to put it in functional terms, like to say, yes, they cannot work because of the fog, because of the pain, because of the loss of mobility. So what's called a narrative letter could be very important from a doctor and be very helpful. But just a blank statement saying my patient's disabled, that means nothing. But what your doctor said, yes, because of these problems, I think, my patient can't work. Here are the reasons why he or she can't get through a 40-hour week. That's what's important, and that's what's helpful in a case.
Well, and that's what I said. Like I said, total all with everything. It was 19 pages, and I swear that won my case because, it was...
Yeah, and it went a long way to helping it. You're fortunate you had that.
It was indisputable, and that was just my one doctor. That wasn't even my primary doctor. So anyway, but that's what I in my advocacy work, I tell people just the more documentation you can't be more thorough. That's the biggest thing.
That is true. Now, that being said, if your doctor would have wrote that letter, but the rest of his treatment notes didn't support that, right, or didn't corroborate that, then Social Security would have threw that away. Exactly. So what's important is that letter was also supported by the underlying medical records. So another part of the advocacy I would tack on to what you're saying, and I'm sure you've told people the same thing, is go to the doctor as often as you can, so we have a paper trail, and make sure the doctor is writing down your specific symptoms and problems, okay? You're not being a whiner by saying I'm having problems A, B, C, and D today. Get it in the file, get it in the record, because if you go in there and say, yeah, doc, I'm fine, and leave it at that, well, that's what the records are going to say when we order them. Right. Patient has no complaints.
Mm-hmm. Yes, exactly. Thank you.
So that's good advice, very good advice. All right, well, yeah, keep the questions coming, but there's one other section I do want to cover before I can answer some more questions here or address some more things, is what's the actual process? Okay, what do you have to do once you want to file for disability? So you leave work, you're not going back to work for the foreseeable future, you want to file a claim. Well, the claim has to be started with the Social Security office, obviously, okay? You could go down and visit the office, all right? What they'll probably tell you to do is to file online. Okay, so you can go to the Social Security website and do it. You can call Social Security's 800 number, which is 800-772-1213. That's a national 800 number. You're going to be on hold a long time, but they'll finally pick up and they can schedule an appointment. Okay, an application could be started. Now, what my law office does is we like to take care of the applications for our clients. All right, so the majority of new clients that I sign up every day, we take from the very beginning. We will do that complicated Social Security application for them. We'll take down the information, do the application online, and walk them through all the steps. So you don't have to have a lawyer from the very beginning. You can choose to do it yourself. Or if you do want to hire an attorney, many attorneys will be willing to take it on from the initial application level. As a quick aside, if you do choose to hire an attorney, the question is, what does it cost? All right. It doesn't cost any money to hire a disability lawyer. We only collect a fee once we win the case. And that fee when we do win is a one-time charge of 25% of any retroactive amount we get for the client when we do win, and that fee is capped at a maximum of $6,000. If you're calling around attorneys fee shopping, that's not going to do you any good. All attorneys charge the identical fee. That's what Social Security allows us to pay, and they pay it to us directly. So there's no fee to hire us, and it's only 25% of that retro amount when we do. That retro amount means Social Security will pay a person back retroactively for all the months and sometimes years it takes to get the case through in one. Out of that one-time back check comes that fee. An attorney does not touch your ongoing monthly benefits. So in any event, that's the attorney fee. So you can choose to file your application yourself online or at the Social Security office, or hire an attorney to do that, which we advise to do. Once the application is in, it generally takes about 4 to 6 months for Social Security to process that application. All right. During that time period, there's going to be a lot of forms that are filled out where you have to list, some of your daily activities, how you spend your days. Somebody who knows you well will fill out a form as well. Social Security will order their medical records from the doctors. They will sometimes send you to see one of their doctors, all right? Social Security will often do that if they don't think there's enough evidence on your own. Well, they'll send you to see what's called a consultative examination, and then that decision will be reached. Typically, Social Security denies about 60 to 65% of all initial cases, depending upon where you live. So generally, nationally, it's about a 2/3 denial, maybe a little bit less, depending upon where you live, okay? I'm not normally a conspiracy theorist. However, I think there's a valid reason why Social Security denies so many people. So I get this all the time. I'm disabled. I've got these problems. Why did Social Security deny me? It's not fair. If you look at the statistics that Social Security publishes of all that pool of people who are denied every year, only half, 50%, ever bother to file the appropriate appeal. So by sticking up these hurdles like this, people give up, go away, and aren't paid the cases that they deserve. So you should really, really, really stay on it. Don't get discouraged if you are denied initially. Another reason, if you so chose to hire an attorney at the first level, because even if it is denied, the attorney will make sure the appeal is filed properly and in time, in a timely manner. If you get that initial denial, there's only a 60-day window to file the appropriate appeal. If you miss that 60-day window, the case is dismissed. As an earlier question asked, could you refile? Yes, you could refile, but you're giving up the time and you're giving up those back benefits as well. All right, so so you got to have that appeal filed within 60 days. I get phone calls every day from potential clients who say, "Hey, I'd like you to help me with my Social Security case. I was denied." Okay, when? 3 months ago, 6 months ago, 8 months ago. Oh, okay, did you ever file an appeal? No. Well, sorry, you're out of luck. We can refile, but you've lost that money and lost that time. So if you're denied, you have a 60-day window to file that appeal. The appeal is called, yeah?
Yeah, as I mentioned earlier, my late wife, she went through that process. She had the scleroderma, she had all the documentation, but obviously she wasn't as fortunate as Michael, and she was denied. But then, within the knowing the law, which is important, and what you're telling what we're telling everyone here, when you are denied, and we can say when you are denied, because 2/3 are approximately, as you put it, you have 60 days, and you better be, pertinent on top of that. So don't wait. We're telling our patients right now, when your denial is received, find your attorney. If you're in Michigan, Levine and Benjamin is a great one. If you're not in Michigan, find your local attorneys to help you do this. Don't wait around. And, I will tell you, it crushed my wife. That basically.
Oh, I'm sorry to hear that.
Well, it's like, wait a minute, as you said, I'm disabled. What's going on? Why didn't they accept it? I have all the documentation, and like Michael, she did. And so from that standpoint, it's hard for the patients, but you know what? That money is yours. So make sure that you do the right things. And if once you receive that letter from Social Security, 60 days, that clock is ticking. Get on it immediately. Yep. And if you don't, like I said, and trust me, have your caregiver or your a significant other or whatever person who's nagging you, listen to them, because I did.
Yeah, I couldn't agree more, and I appreciate the plug. About calling us if you're in Michigan. But as I said from the beginning, we do these cases all over the country. So if you're listening to this in a state outside of Michigan, I might also be able to help you too. Or at the very least, you can call me and I can give you some advice. If you choose to hire a local attorney, that's okay. But I handle these cases all 50 states. And my clients don't have to come and see me. We handle the paperwork through the mail and email, and phone like that. And that's, again, another reason why if you chose to get an attorney from the very beginning and not wait till you're denied, the attorney's there to file that appeal right away. And that appeal is called a reconsideration. So basically what you're doing is you're asking Social Security to reconsider the original denial. It goes back to the same people who looked at it the first time, and surprise, surprise, they usually deny it a second time. Statistically, about 85% or above of all reconsiderations are denied. It's silly, but that's the way it is. So if you receive one denial, you file the appeal called a reconsideration, usually about 3 to 4 months go by, you get a second denial, all right? Once you get that second denial, then you get the opportunity finally to go in front of a judge. So you file what's called a request for a hearing. And then that next step allows you to go to an administrative hearing where you get to go in person, sit down in front of a judge and explain the case. Now, did your wife go to a hearing?
Yes, she did, and like I said, she's sat down in front of the judge. I'll let you continue, and I'll share the story of what happened.
Okay. Okay. All right. So once you file that appeal, get a request for hearing. As I mentioned, you get a chance to go to a judge. What you were going to be doing, and hopefully your attorneys will be doing, is getting updated medical records, getting statements from the doctors. Before the hearing, most judges require what's called a brief, or basically a recitation of the facts and what your legal arguments are as to why finding of disabled should be met. And then you get to go to that hearing. The hearing is pretty informal, meaning it's not like anything you see on TV. There's no jury. There's no opposing attorney against you. So you as the claimant, that's called, the person seeking disability, sits at one end of the table, the judge sits at the other end of the table. There'll be somebody there recording the proceedings, and there'll be somebody there called a vocational expert who will give some information about the job issues and numbers in the economy. Most hearings generally last about 30 to 60 minutes, usually depending on the particular judge. It's pretty quick. The judge usually doesn't tell you if you won or you lost that day. The judge will set out a written decision after the fact. Now, the time waits to get hearings nationally are going down, which is good news. Good. I used to tell my clients, as close as 2 years ago, expect a 14 to 18 month wait to get that hearing once the appeal is filed. Right now, the time waits, depending on where you live, could be about 7 to 10 months from the request for hearing. It's still not ideal. You still have to wait, but 7 and 10 months is a lot quicker than 14 to 18 months. So that's kind of what we're looking at. So a typical case that has to go to a hearing, if you think back, from application to reconsideration to hearing to ultimate decision, could be 1.5 to 2 years. That's the typical time frame, okay? Now, in front of that judge, statistically, about 2/3 of people are approved. So I said initial level is about 2/3 denial. Well, it's about 60+% people are approved at the hearing. So you got a much better shot, and it makes sense. Somebody actually gets to speak to you, look you in the eye. As an attorney, I finally get a chance to make oral arguments on behalf of my client, all right? And that's usually when cases are won. If a case, however, is not won at a hearing, there's further appeal rights. You can file then to what's called the Appeals Council. The Appeals Council is the last step of adjudication with Social Security. It's a panel of judges in Falls Church, Virginia. You do not get a chance for another hearing. Just the panel of judges look at the decision. Usually takes about another 6 to 12 months to get a decision at the Appeals Council. They deny about 90% of all cases. So your chances of success are pretty slim at the Appeals Council. If you don't like what the Appeals Council did, then you can file further appeals into the United States federal court system. Now, we do take some cases to the federal court, but we have to be very picky. When you go into federal court, you're not arguing anymore if my client's disabled or not. You're arguing, was there some error of law that the judge did in the decision? Did he or she misapply some area of the law that now the federal court has to look at? That could happen. That sometimes happens, but it's very difficult and rare. So that's basically the whole process from start to finish. Now, you had a comment about the hearing?
Yeah, one of the things I wanted to share is that after she saw the judge is that the case was approved, and like you said, the judge wrote a 10-page basically brief on the hearing basically, and what he did say within the hearing, and it did say within the document, it said he was ashamed, or basically that this case should have never been brought to him and should have been approved at the first time. And that basically is that the Social Security process did not do their job. Okay, so that was one thing that was very interesting. The other thing I wanted to, as you were talking about, and he did cite in his brief after the hearing, was that I asked the lawyer, he says, can I write a letter to the judge? Because as you say, I was not allowed to be part of the process. It was just my wife, the attorney, and the other person from Social Security. So I wrote a letter describing that what are the things that my wife could do and then the things that she couldn't do anymore and the things that she used to enjoy that were now taken from her on a very personal note. And he said that that had a lot of impact. So
Sure.
So what I want to make sure is that, excuse me, it's only been 3 years, is that making sure that the caregivers do write a polite letter, you know, from the standpoint of citing the things that, you know, their significant other or spouse or the person that they're giving care for used to be able to do and no longer can do because of the disease of scleroderma. So like I said, we can have some impact, but it's like I said, it is important to keep working at it and do the things that you have to do.
That's good advice. A judge is only human, so a judge can certainly be swayed by things like that. You know, that this is how this affects my loved one's life. This is how they are now. This is what they can't do like they used to do before, and that certainly can sway and help persuade a judge. An entire Social Security hearing is based upon a person's credibility. If you think about it, a judge is looking my client in the eye and saying, do I believe him? Do I believe her when she says she can't work anymore? If the answer is yes, I do believe what she's saying, benefits are awarded. If the judge looks at my client and says, no, I don't believe what he's telling me, I think he's exaggerating, I think there's still some work that he can do, the case is denied. So anything we can do to try to make your story believable. I mean, you live it, but letters from a loved one, but more importantly, documentation from the doctors, the records, statements from the doctors, you know, proper representation to explain why your condition fits within the disability criteria. All of that will make a judge believe the case.
Thanks, Gary.
Sure. Last thing I want to talk about is that there have been some changes in the law. Now, for instance, I mentioned about that reconsideration level. Michigan didn't used to have reconsideration. Okay, Michigan was one of 10 states who got rid of that reconsideration some time ago. When you got that initial denial, you went right to a judge, and they got rid of that middle level. Well, there were 10 states that did not have reconsideration, but now they're bringing them all back. Now all states have that reconsideration. The bad news for that is, unfortunately, it drags the case on longer for most folks because they have that second level of normally a rubber stamp denial. Some people will get a decision at reconsideration favorable, most don't. Now, and there's also been some proposed changes. I certainly don't want to get political here. I know this is not the cause of why we're here today, but the current administration is putting out some proposed rules that are going to make it harder for people to stay on disability. So once you're on disability, they're going to be cutting a lot more people off, and they're even considering making some rules tougher to even get on disability to begin with. That age 50 rule might be shifted to age 55. So just keep that in mind. That's not law now. I don't want to panic anybody, but those are considerations, and there are things that this current administration is putting out there just to kind of consider as we're going into this next election cycle. If you care, have people on disability, or is this something important to you to consider about what this administration is considering here? Is there any other questions or anything else you'd like to address?
I got a couple questions.
Yeah.
What, and this only because it happened to me, is I'm going to say, what do you do when you find out your employer failed to either report your FICA numbers or pay into it?
That's a problem.
That was
You're
a
gonna
problem.
have, yeah, that's a huge problem.
It
You're
was.
gonna have to, you're gonna have to show those earnings to Social Security to get them updated. Show your W-2s.
Luckily, I had all my W-2s to send, and you know, it was karma, because it kind of goes back, and this isn't a question, it's more like a statement, because technically, when you're filing for disability, you're not disabled till you're labeled it by the Social Security Administration. So you don't fall really under the American with Disabilities Act. So in the meantime, I worked for 3 months knowing that I was going to retire, and I finally just quit because I was being harassed. Though, and I should have, it'd been great to be able to file. They violated my rights, but anyway, it was karma because they got fined a lot of money. But yes, important to keep all your records because obviously the W-2s saved me on that thing. Another one.
Glad you had those. I glad you had those. I get calls from people who say they didn't report my earnings, and I say, well, do you have your W-2s? No. Well, you're not going to be able to fix it if you don't have those or your tax returns.
And stupid me, I used 2 years ago go online and check that out. I hadn't. And at the time I was there 5 years or 7 years, and 5 of those 7 years were not reported. So anyway, I had that. Is there a 5-year review process in the Social Security? I'm told that. Like if you're on it for 5 years, you get reviewed to make sure that you're still disabled.
Some people are reviewed, most are not, but that's under one of the proposed changes that I mentioned that this administration is looking at. They're looking at reevaluating most people every 2 years.
Okay.
Which would that's not law yet, but if it becomes law, that's going to make thousands of people get cut off.
Right.
Well, also, it's two things also besides cutting off. It'll slow down the process of new files being approved or being looked at, unless they hire more people to do that.
That's a good point, which I'm sure they're not.
Yeah, well, we know they never add more people when they add more work. So from that standpoint,
yeah, they're not different than any other employer. Exactly.
That's very true. No, Gary, I'm good with a lot of the questions and the interaction. I appreciate it. Michael, anything else?
I got one more because I put it out on the advocacy websites. What if you choose to re-enter the workforce? Whether you not even against your doctor's orders, but because, and this isn't for me, you're just plain broke and you need money. What do you do? If you just
sure, that's a good question.
Yep.
All right, so it depends upon when you do it. All right, if you go back to work while your case is pending, okay, well, you haven't before you got that decision. If you go back to work after 12 months, we can still get you benefits for what's called a closed period for the time that you are off, but there has to be a minimum of 12 months. If you go back to work before 12 months is up while your case is pending, your case is going to be dismissed. But however, as I mentioned, though, there's that unsuccessful work attempt, so that if you go back to work and it lasts longer than 3 months, then your case would be dismissed. But if you go back to work and it lasts less than 3 months, we can label that an unsuccessful work attempt and your case will continue, okay? Now, let's say you win your case and you decide you want to go back to work, which is pretty common. Well, you can do that. Social Security offers what's called a trial work period, okay, where you can work as much as you want and get your full Social Security benefits for up to 9 months, okay? But after 9 months, if you're still working and above that substantial level, then your benefits will be ended. Now, every 5 months every 5 years or every 60 months, you get another 9 months of trial work where you could use to try to dip your foot back in the work pool.
Okay, cool. Good, thank you.
All right. Hey, well, I appreciate you gentlemen having me and all the great questions and interaction. To the folks out there, you see my website. I'm happy to correspond with anybody throughout the country via email or give me a phone call. I'm happy to give any advice or speak to anyone who has any other questions about disability.
And as you can see on the screen, I have Gary's name and also his website. So from there, you can gain all the information on his phone. So, Michael, I'll turn it over to you to allow you to wrap it up.
All right. Thank you so much, Gary, for presenting today for the Scleroderma Foundation. I know this information has been very beneficial to all of us, and including me. Thank you for helping to educate the Scleroderma community. Staying educated about your disease or the disease that affects the life of your loved one can help you become a more effective health care advocate. If you have questions about anything that has been presented on this webinar, it is best to bring them to your local medical team as they know your specific medical needs and you can help them make the right decisions. And if you have any particular questions regarding Gary, we've got the contact information there. Thank you again for viewing this webinar and have a great day.
All set?